The House offers the following substitute to Senate Bill 238. A bill to be entitled an act to amend Chapter 1 of Title 1 of the OCGA relating to general provisions, so as to revise provisions relating to the enactment of the OCGA to clarify the portions of the code which have the effect of law and for other purposes. This completes the order, Mr. President.
Chair recognizes the senator from the 17th to speak to his motion.
Thank you, Mr. President. Senate Bill 238 was the bill that everyone voted for that came in response from our Code Revision Commission in response to a Supreme Court case that created some confusion about what we actually print as legislators in our contract, printing, a lot of words, the code every year in that big code book that you see. The House just made a couple tweaks based on suggestions of Legislative Counsel on how he worded some of this. No substantive changes are made to this bill. I ask for your favorable consideration. Happy to answer any questions.
You have no questions.
Thank you.
Any of the senator wish to speak for or against the motion? The chair sees none. The senator from the 17th has moved that the Senate agree to the House substitute to Senate Bill 238. All those in favor of the motion signify by voting yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Ms. Secretary, please close the machine. On the motion, the yeas are 51, the nays are 0, and the Senate has agreed to the House substitute to Senate Bill 238. Chair recognizes the senator from the 56th.
Mr. President, I move we gracefully agree to the Senate amendment to the House substitute for Senate Bill 59.
There's only one flavor of agree. Just to clarify, will you state your motion again, just to clarify it for all seriousness here?
Agree to the Senate amendment to the House substitute for Senate Bill 59.
As amended by the Senate?
Correct.
Ms. Secretary, please read the caption.
Senate Bill 59 by Senators Albers of the 56th and others. A bill to be entitled an act to amend Chapter 2 of Title 20 of the OCGA relating to elementary and secondary education so as to provide for additional QBE funding for each full-time equivalent student with a local charter school to provide for a maximum amount of such funding available to each local charter school and for other purposes.
Chair recognizes the senator from the 56th to speak to his motion. First, we're going to read the amendment first. Apologies.
Senator Albers of the 56th offers the following Amendment 1 to amend the House Committee on Education substitute to Senate Bill 59 by inserting after so as on line 2 to prohibit the waiver of early intervention program requirements in local school system flexibility contracts and for other purposes. This completes the order, Mr. President.
Now the chair recognizes the senator from the 56th to speak to his motion.
Thank you, Mr. President. If you remember, Senate Bill 59 was the update to the charter schools. The House took off the area for the facility stipend, and then we, in working with the governor's office, is adding a very small amendment, has to do with the Early Intervention Program, EIP. This is different from when we think of the IEP, which is the individual education plans. So this simply makes sure that There's no outside waivers going on, that we stay focused on that plan, which allows us to keep the matching funds and working together to make sure these students get the need in the schools that will make them successful. If there are no questions, I'll yield the well.
You have no questions. Any other senator wish to speak for or against the motion? The chair sees none. Senator from the 56th has moved that the Senate agree to the House substitute to Senate Bill 59 as amended by the Senate. All those in favor of the motion signify by voting yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Tell your neighbor to vote. There you go. Have all senators voted? Ms. Secretary, please close the machine. On the motion, the yeas are 40, the nays are 11, and the Senate has agreed to the House substitute to Senate Bill 59 as amended by the Senate. Chair recognizes the senator from the 50th for a motion.
Mr. President, I ask that we remove House Bill 409 from the table.
Ms. Secretary, will you please read the caption?
House Bill 409 by Representatives Gunter of the 8th and others, a bill to be entitled an act to amend Article 4 of Chapter 15 of Title 45 of the OCGA, relating to counsel for public officials and agencies so as to provide for a process for state-funded representation of certain judges in legal actions resulting from performance or non-performance of their official duties and for other purposes. The Senate Committee on Government Oversight recommends that this bill do pass by substitute. Respectfully submitted, Senator Harbin of the 16th, Chairman. The Senate Committee on Government Oversight offers the following substitute to House Bill 409, a bill to be entitled an act to amend Article 4 of Chapter 15 of Title 45 of the OCGA relating to counsel for public officials and agencies so as to provide for a process for state-funded representation of certain judges in legal actions resulting from performance or non-performance of their official duties, to provide for a definition, to establish a judicial legal defense fund, and for other purposes. This completes the order, Mr. President.
Senator from the 50th has moved that House Bill 409 be taken off the table. Is there objection? The chair hears none, and it is taken off the table. The chair recognizes the Rules Chairman's roommate, the very busy freshman, the senator from the 50th, to present his measure.
Thank you, Mr. President. I come to the well today to present House Bill 409. This bill would create the Judicial Legal Defense Fund to provide state-funded legal representation to defendant judges in proceedings authorized by the new provision authorized in this language. It would also create the Joint Legal Defense Fund Commission, which would be governed by 5 members. These 5 members must be active justices of the Supreme Courts or judges of the Court of Appeals, statewide business courts, or Superior Court, or appointed by certain individuals by other provisions in this bill with the advice and consent of the Senate. Members will serve 2-year terms and will not be compensated for their service, but reimbursed with per diem of the same amount of the General Assembly and travel expenses. The goal of this commission will be to evaluate requests from defendant judges and maintain a list of attorneys in good standing with the State Bar who have offered to provide representation for judges and have received approval by the governor. The final cost of the proceedings must be submitted to the commission, and any excess funds must be returned. This bill would not prevent a judge from choosing their own representation at their own expense. And this bill passed unanimously in the House. And Mr. President, I will yield for questions, if there are any.
Chair recognizes your roommate, the Rules Chairman, for a question.
Thank you, Mr. President. Let me give you great regards for how you read that bill to us just then. And I was wondering if you could actually tell me what it does.
It creates a legal defense fund for defendant judges.
Shazam. No more questions.
Do you continue to yield?
I do.
Chair recognizes the senator from the 6th, to your right.
Will the senator yield?
Yes, I will.
With respect to this, it's my understanding that the governor may direct the attorney general to provide such counsel to judges. Is that correct?
That is correct.
So does this only is this only triggered when the governor orders the attorney general to provide the defense to the judge and the attorney general refuses to comply with the governor's order?
No, it would actually be if a suit is brought against a judge and the executive branch, the attorney general has to represent the executive and would be have to recuse themselves from representing a judge. That's the loophole or the issue that we're trying to help here. In the past, a judge has been appointed, but we had to use emergency funds to represent the judge, and this just creates a legal fund.
Will the senator yield?
Yes.
You seem to indicate that then this is only in play when the executive branch and a judge is sued. But that's not my reading of the bill, because of you said that there was a recusal issue in terms of conflict, but that's not required, correct?
Correct. It would be if the attorney general is unable to represent the judge, then a legal defense fund is created to make sure that judge has representation.
Unable or unwilling?
The senator knows of what she speaks.
You have no more questions.
Thank you, Mr. President. I'll yield the well.
Any other senator wish to speak for or against House Bill 409? The chair sees none. The question is on the adoption of the committee substitute. Is there objection to adoption of the committee substitute? The chair hears none. The committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Ms. Secretary, please close the machine. On the passage of the bill, the yeas are 48, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 45th for a motion. Chair recognizes the senator from the 45th from Gwinnett County for a motion.
Mr. President, I respectfully request that we move House Bill 128 from the table.
Mr. Secretary, please read the caption.
House Bill 128 by Representative Williams of the 145th and others, a bill to be entitled an act to amend Chapter 1 of Title 31 of the OCGA relating to general provisions regarding households to prohibit providers from discriminating against potential organ transplant recipients due solely to the physical or mental disability of the potential recipient and for other purposes. The Senate Committee on Health and Human Services recommends that this bill do pass. Respectfully submitted, Senator Watson of the 1st, Chairman. Senator Goodman of the 45th and others offers the following Amendment 1 to amend House Bill 128 by replacing line 10 with the following: benefit plans and collective bargaining, to provide for applicability, to amend Chapter 39 of Title 31 of the OCGA relating to cardiopulmonary resuscitation and for other purposes. This completes the order, Mr. President.
For what purpose does the senator from the 2nd rise?
Mr. President, I ask for unanimous consent to excuse the gentleman from the 15th.
Without objection, the senator from the 15th is excused. Senator from the 45th has asked for unanimous consent for House Bill 128 to be taken off the table. Is there objection? The chair hears none, and it is taken from the table. The chair recognizes the senator from the 45th to speak to the bill and the amendment.
Thank you, Mr. President. Every day, the General Assembly strives to value every life of every Georgian. House Bill 128 and the amendment that we'll be offering does just that. It ends discrimination. It shows that we value every life and aligns with the values of who we strive to be as a state. Organ transplant discrimination is a real problem where people with disabilities are being told they're not eligible for organ transplant based solely on disability diagnosed in their medical records, and the consequences for some are fatal. In Georgia, we're doing nothing to protect those with physical and mental disabilities from this discrimination. Gracie's Law, named after Gracie Nobles, who many of you have seen around the Capitol this past week, addresses this issue by simply providing immediate local relief in Georgia courts for those who are victims of organ transplant discrimination. Gracie's Law passed unanimously in the House as well as in the Senate Health and Human Services Committee and is supported by a broad number of faith-based groups, disability and healthcare advocates, and more. This bill is a bipartisan sponsorship and support, and I'm grateful for the leadership of Representative Rick Williams and Representative Max Jackson, who have shown through this effort. This is a simple bill, a simple common sense bill that policy shows that we value every Georgian. I'll now go through the friendly amendment. This amendment was designed to incorporate the language from Simon's Law, which was passed unanimously by this body in 2018 and in 2019, into Gracie's Law. This language also passed the House unanimously this session. Chairman Chuck Payne has been leading on this issue for years, and I'm grateful for his work. It's named for Simon Crozier, who was born with trisomy 18 and was awaiting heart surgery when his oxygen levels began to drop and his heart began to give out. Despite desperate pleas from his parents, Simon was refused care and he tragically died. He was only 3 months old. His parents learned soon after that his attending doctor had placed a do not resuscitate order on his medical file without their knowledge or consent. And currently in Georgia law, their consent is not required. As a parent, I couldn't imagine being robbed of this decision. Georgia law allows for this very same scenario to take place in our hospitals And we've heard numerous tragic stories about previous lives that we've lost and parents' rights were not respected regarding their children's medical care. Other states have begun to take action and put similar laws into place on their books. Simon's Law, through this amendment, would put an end to that simply by requiring doctors to obtain consent from parents before placing a DNR on a minor patient's record. This amendment is supported by the bill's author and Gracie's family. And with that, Mr. President, I'll be happy to answer any questions, and if there are none, I'll yield the well.
You have no questions.
Thank you, Mr. President.
Any other senator wish to speak for or against House Bill 128 or the amendment? The chair sees none. All right, we're going to take up the adoption of amendment number 1 by the senator from the 45th. Is there objection to adoption of amendment number 1? Chair hears none, and amendment number 1 is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill as amended. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Have all senators voted? Ms. Secretary, please close the machine. On the passage of the bill, the yeas are 52, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed as amended. Chair recognizes the senator from the 56th.
Mr. President, I'd ask unanimous consent and with great importance to remove House Bill 255 from the table.
Ms. Secretary, please read the caption.
House Bill 255 by Representatives Holcomb of the 81st and others. A bill to be entitled an act to amend Chapter 24 of Title 15 of the OCGA relating to sexual assault protocols so as to require certain certifications to be filed, to amend Article 4 of Chapter 5 of Title 17 of the OCGA relating to investigating sexual assault and for other purposes. The Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th. Chairman. This completes the order, Mr. President.
Senator from the 56th has asked for unanimous consent for House Bill 255 to be taken from the table. Is there objection? Chair hears none, and it is taken off the table. Chair recognizes the senator from the 56th.
Thank you, Mr. President. House Bill 255 is a result of the recommendations of the state's expert committee on sexual assault. I want to give a lot of credit to the great work done by Representative Scott Holcomb, as well as this Senate body. We have partnered over the years, added significant dollars to the budget for the GBI to help with scientists with sexual assault kits to get rid of the backlog. This bill updates some of the code around that of how we report the sexual assaults, the protocols, and clarifying language for unreported sexual assault kits, improving our coordination with the FBI and the Violent Criminal Apprehension Program, also known as VCAP. This establishes a statewide sexual assault kit tracking system for the first time. Section 2 of the bill says that each judicial circuit is going to have a sexual assault protocol. Some of them have done a phenomenal job, and others are behind the curve, and we need to have a consistent model for everyone. This will be important for each area to be in compliance. Section 3 revises the current code for unreported sexual assault kits, because time is of the essence and victims must be present for medical care after an assault. However, as we know, not all victims are ready to report to law enforcement because there could be some compelling reasons as to why not. If a victim does not cooperate with law enforcement, this allows them later on to infer the victim is doing something right, not necessarily something wrong. Section 4 is really the meat of the bill, and this creates the statewide tracking system for our sexual assault kits. This gives victims the ability to track the kit through the process, working with CJCC. This will keep us consistent with 27 other states, including the District of Columbia. And once operational, the CJCC will report this data back to us in the General Assembly and provide details about the testing, the average time it took to get that kit tested, the evidence tested, and the number of kits that are remaining. There is very small fiscal impact, and it will be funded through a grant through CJCC. And last but not least, in Section 5, this improves the coordination with FBI and VCAP, which these are the hardest and most difficult cases to prosecute to solve serial murders and rapists. The goal is to improve information and ultimately put the bad actors away. Overall, these measures will improve the state's response to sexual assault, and I request your favorable consideration. If there are no questions, I will yield the well, Mr. President.
You have no questions. Any other senator wish to speak for or against House Bill 255? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 49, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes, for what purpose does the senator from the 10th rise? For what purpose does the senator from the 10th rise? He waves. Chair recognizes the senator from the 3rd for a motion.
Mr. President, I ask for unanimous consent that House Bill 338 be taken from the table.
Mr. Secretary, can you please read the caption?
House Bill 338 by Representatives Deloach of the 167th and others, a bill to be entitled an act to amend Code Section 40-5-36 of the OCGA relating to veterans' licenses, honorary licenses, and other distinctive driver's licenses so as to revise qualifications for issuance of veterans' driver's licenses and for other purposes. The Senate Committee on Veterans, Military, and Homeland Security recommends that this bill do pass. Respectfully submitted, Senator Kirkpatrick of the 32nd, Chairman. This completes the order, Mr. President.
Senator from the 3rd has moved that House Bill 338 be taken off the table. Is there objection? The chair hears none, and it is taken off the table. The chair recognizes the senator from the 3rd to speak to the measure.
Thank you, Mr. President. This bill seeks to expedite the process to help our veterans obtain their veterans license plate. Instead of waiting hours at the VA, they will have the ability to take their DD-214 directly to the DMV or tag office to prove their veteran status. It passed the House with 0 nay votes. I hope it will do the same here. Mr. President, If there's no questions, I will yield the vote well.
You have no questions. Does any of the senator wish to speak for or against House Bill 338? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill? All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Mr. Secretary, please close the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 16th for a motion.
Mr. President, I ask that for unanimous consent for House Bill 532 to be taken off the table.
Ms. Secretary, please read the caption.
House Bill 532 by Representatives Werkheiser of the 157th, a bill to be entitled an act to amend Title 34 of the OCGA relating to labor and industrial relations so as to change certain provisions relating to the Department of Labor and Employment Security, to authorize the Commissioner of Labor to designate peace officers to carry out and enforce provisions relating to labor and industrial relations and for other purposes. The Senate Committee on Insurance and Labor recommends that this bill do pass. Respectfully submitted, Senator Burke of the 11th, Chairman. This completes the order, Mr. President.
Senator from the 16th has asked for unanimous consent for House Bill 532 to be taken off the table. Is there objection? The chair hears none, and it is taken off the table. The chair recognizes the senator from the 16th to present the measure.
Thank you, Mr. President. This is a housekeeping bill for the Department of Labor. It deals with some cleanup issues that are there. It first deals with the issue of Section 1 with an address that is consistent for all documents to go to at the 148 Andrew Young International Boulevard address. It deals with the issue of the duties of the and powers of the Labor Commissioner to conform with federal law, and then it cleans up some on extended unemployment benefits to be referenced to federal laws as well, and pretty just a cleanup department bill.
You have no questions. Senator has yielded the well. Does any other senator wish to speak for or against House Bill 532? The chair sees none. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill? All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. Have all senators voted? Have all senators voted? Ms. Secretary, please close the machine. On the passage of the bill, the yeas are 50, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. All right, we're going to stand at ease for 30 minutes. Let everybody stretch out their legs a little bit. Let us catch up on the paperwork. We'll be back at 4 o'clock. We'll stand at ease until 4 o'clock.